District Court of County of Washington, State of Michigan is now in session. Time of business before the court draw near. The Honorable Judge J. Simpson preside.
You may be seated.
All right, here we go. I have to thank Zach over at Law Nerds Unite. With this is the trial. I did a prior video on this. I can't find it, but when I do find it, I'll put a link to it in the description below. I think I called it, Does Judge Simpson Hate Landlords? I don't know. It's making me crazy. Both the landlord and the tenant are completely insufferable. Let's do this.
She's coming in. Court does call the case of Anderson versus Lyman. State your appearance, please.
Armani Lyman.
All right, Miss Lyman. When the court says 9 o'clock, I mean 9 o'clock. We're waiting for you to appear at the courthouse. So that won't happen again, correct?
Yes, sir.
All right. This is date and time set for trial. Each side ready to go to trial?
Yes.
All right. Sanderson, you may proceed.
Should I stand there, sir, or right here?
You can stand wherever you want, that you'll be picked up on a microphone.
I want to give my opening statement. And then I have one.
Go ahead. Do your opening statement, please.
Okay. Your Honor.
Ma'am, put the microphone back where it was. It will pick you up.
Sorry about that, sir. Your Honor, my name is Lori Anderson, and I am the plaintiff and owner of the property at issue. I am here seeking a judgment for $14,606.46, which includes unpaid rent, court costs, unpaid water bill, and damages in the amount of $2,866. Ms. Armani Lyman provided false information on her rental application, including misrepresenting her residency. She didn't have my decision to rent my home to her. This is not a typical landlord-tenant dispute. She has a documented history of property damage, unpaid rent, and destructive behavior, as shown in the exhibits and witness testimony I represent. I want to acknowledge that I appreciate the court's efforts in landlord-tenant cases to maintain tenancy for individuals who might otherwise be homeless. However, this case is different because it involves actual.
It sure is awful. We kick it off with both of them dressed completely inappropriate for court. I mean, that's a draw, just for starters.
Property damage and destruction, not just homelessness. If the court allows Ms. Lyman to remain a tenant, I respectfully request safeguards to protect my home, because this is the only way I will have access to my property. The defendant will not allow me into my home and does not communicate with me outside of the court. While the lease allows me access with a 24-hour notice, Ms. Lyman has denied me entry, making court-ordered inspections necessary. Therefore, I request that
This was a trial that occurred today. I did a previous appearance between these two.
Court order monthly inspections at a specific time each month so that these inspections are enforceable and I can return to court if Ms. Lyman fails to comply. Monthly property inspections with Mr. Ivory Clinton present to detect smoking inside the home. Inspections scheduled once per month on a Saturday at a specific time set by the court, preferably 10 or 11 a.m. During inspections, I request permission to take photos of the property condition. I request access to inspect the entire home, including the basement and garage. I will bring an HVAC filter to the inspection and replace it monthly as part of regular maintenance. Inspections will confirm that there are no unauthorized occupants, no further property damage, and no smoking inside the home. I asked the court to instruct Ms. Lyman to allow access to the home for myself and a licensed contractor on October 2nd to repair a crack in the basement, scheduled to start between 8 and 10 a.m. and expected to last several hours. I am also respectfully requesting that the court return 2 zip drives in my possession. I did not present any video evidence in this trial, and these drives contain precious family memories. For this reason, I ask that these videos not be included as evidence. These measures are essential to prevent repetition of past destructive behavior, ensure compliance with lease terms and local laws, and allow me reasonable access to my property. I respectfully ask the court to grant judgment of 46 cents and Ms. Lyman's remains content to consider implementing court order protective measures to safeguard my home. Thank you, Your Honor.
Ms. Lyman, opening statement.
Okay, so I have not been able to peacefully stay in the house. Every time I turn around, she's either down the street or have somebody watching me. So I would really like to be able to enjoy the home, which I haven't. I pay all this money to not be able to enjoy the home. I don't smoke, so there's no smoking happening on the property. There are no damages. And the judgment, that seems like a much, because she's including the rent that I had paid to you guys in escrow in the judgment. Also, I would like an addendum to the lease for my $750 that she said that she legally lied and said that she didn't know that she can put it as non-refundable because somebody else is suing her for the same $750. When I moved in May, I paid $3,300. It should have been prorated because I moved in on May 5th. So that should have been prorated $533 plus the extra $300 that's left over from the deposit. In June, I paid an extra $200. So I ended up paying about $500. In July and August, I paid the $3,300. The only month I owe is this month. So from
This month being September or
yes,
October?
I can pay that tomorrow. The so only every month is $3,300. So with the extra money, me paying the $200, prorated the $530, the extra $300 from the deposit comes up to $1,033. So I figured that I should take that from the rent, and it should be $2,267.
Yes, this is that same case. I don't know that we all concluded that, but a darn fine argument was made. In the prior hearing, she had extremely high electricity and water bills and was paranoid about anybody going downstairs. So the supposition was that maybe she's growing weed downstairs, which, I don't know if she is or isn't, but that sure would explain all of that.
That you owe.
Yes.
So Anderson, you may call your first witness. Is that going to be yourself or somebody else?
Should I stand there to question the witness? Where should the witness stand there?
It's up to you. Where do you want to stand?
Clinton? Oh, you see, my witness.
Sir, please come forward and be sworn.
State and spell your first and last name for the record.
First name is Ryan, because you are you are my two.
Your Honor, may I give this to Mr. Clinton to reference?
I don't know what it is.
Evidence pack number 4 that I've already.
No, that's not the way it's done.
Oh.
You can question him and then.
Okay. Mr. Clinton, how long have you known me, the plaintiff, Miss Anderson? Can you hear, hon? How he has a hearing trouble.
Get him equipment so he can hear the question.
Thank you, Mr. Clinton. Mr. Clinton, how long?
I
have
got
you
my
known
head
me,
covering right
the
here.
Plaintiff, Miss Anderson. Okay. In your experience, how have you known me to maintain
And she looks just as ridiculous as me.
my home, its cleanliness, its floors, the overall condition? Almost perfect? Okay. Do you recall when I was preparing the home for sale in the spring of 2025? Okay. Do you recall the condition of the home when it was listed on the market in April 2025? Looking at the before and after photos in Exhibit 4, did you ever see a rear screen?
Exhibit 4 hasn't been admitted. I don't know.
I have,
Yes.
yes, sir. I gave them all to the clerk on
It hasn't been admitted, ma'am.
the clerk. I came here on Friday and Ann, or was it Ann?
Andrea, Food Fairy, and Iris are also in on this conspiracy.
She said she would give it to you. She gave it. I put it in a packet. And
It hasn't been admitted
how do I
trial.
admit it?
Ma'am, I can't tell you that.
Okay. Okay. So
I don't know who took the photos. I don't know when they were taken. I don't know.
Yeah, there's no foundation. Now, he would let it slide for a tenant. Don't get me wrong. I can't stand this woman, so I think it's funny. I'm enjoying it. But if a tenant went up there and threw some pictures at him, he'd be like, "Oh yeah, it admitted in evidence." Next.
Any of that about these purported photos.
well, how can I get what I dropped off on Friday to you? So I thought you had them. I actually spent a lot of money to produce the color prints. It cost me over $20.
Ma'am, whether I have them or not doesn't mean that they've been admitted into trial. Who has to establish those photos and then attempt to try to have questioning regarding those photos.
Okay, I'll do that. Can I admit Exhibit
All of that is correct.
4 into court?
No.
Ma'am, who took, I don't know who, there's no testimony.
There's also no objection. So it's certainly within judge's discretion to admit them right now. I'm not saying he should. I'm not really having a problem with him. She hasn't laid a foundation or whatever, but he could just in this. There's nobody. She's moving these photos into evidence right now, and nobody's objecting. He can just say, sure, I think these are actually photos of that. There's also no foundation, but he's effectively making the objection himself.
To who took the photos,
The
what
professional
their photos are,
of my house, the professional photos of my house, and then I took the photos of the damages.
and you need to testify about the photos.
Okay,
Yeah, you can't just say it. You have to be under oath and testify. Who, what, where, when. That's the foundation.
so what, do you want me to say, go over Exhibit 4 with you?
I just want you to do the trial, but I'm not going to just have you submit things, and I don't know if they've been presented
Thank you.
to.
Yeah, no,
Yeah, this isn't trial ad. You're supposed to know how to get your exhibits into evidence. Or, now this is controversial, but think about it. Maybe you could get someone who knows how to do that. They call those people attorneys.
I sent her all the files, all the files to the defendant.
I don't know what those files are.
The exhibit, can we, I spent a lot of money bringing the exhibits to court. And I dropped them off on Friday. She did a stamp.
Aw, sucks for you. You spent all that money and you don't know how to lay a foundation. Wah, wah, wah.
She put a stamp on them to give to you. And she said, everything's fine. And so I thought you had the exhibits. I labeled them. I emailed them to you, but also printed them out, but I labeled them exhibits.
Maybe you're not understanding me. You can send to the court whatever you like. It doesn't make them an exhibit in the trial.
So how do I send them to be an exhibit to the trial?
It's not his job to tell you.
I am not here to
More to the point, it's his job not to tell you.
assist necessarily either side in this trial. Ultimately, the court considers evidence in the trial. You need to properly admit it.
So how do I properly admit the evidence, sir?
I'm not here as your lawyer, ma'am. I'm here as a judge.
Okay, so you want me to just ask him the questions then? I'll ask him the questions.
Meanwhile, this is really hard because A, you don't want to sit there while they flop around because it's boring. And B, he knows damn well how to admit them. but he's not supposed to, because then he's providing counsel for one of the sides. And if he's going to do that, he's going to do it for the tenant, not the landlord.
Do you ever, Mr. Clinton, do you ever remember seeing the rear screen door ripped?
No.
Do you ever remember oil stains in the driveway? Do you ever remember me mounting a security camera on the south end of the home? Do you ever recall the master bedroom blinds being broken?
No.
And the front door lock, it was never an automatic door lock. It was always a mechanical door lock, correct? Okay.
This hurts.
Can you confirm for the court that the before photos accurately?
I mean, why don't you just say she's leading? Because she is. I mean, if you're going to make objections for the defense here, why don't you just keep going, Judge?
Represent the condition of the property before Ms. Lyman took possession, May 5th, 2025.
Where did these photos come from?
Now he helps her. He actually helped her. Just because it's killing him. He didn't want to, but here he is helping her.
They were photos I took when I was after the home was prepared for sale.
Graham? You took the photos.
No, they were taken by a professional because they were actually put in the MLS.
How's he going to establish that? You need the professional here.
The professional photos were taken, they were put in the MLS, and then I took the damage photos.
What did I just say?
Okay, that's great. That's great. But you're acting as your own attorney right now. You're not on the stand. So you can't just speak in the elements of foundation, which you're not doing right anyway. He's leading you towards it. But you need to be under oath and testifying. Then you need to, get off the stand and run over to the counsel table and say, I'd move these into evidence. And Big Dummy over there won't object because she doesn't know anything. And there you go.
Okay. Who took the photos?
The professional photos, 2 people.
Oh,
2 people.
he did not take the photos.
No,
You didn't take these photos.
I took the after photos. The before photos were professional photos for the home to be in the.
Question.
Okay.
The photos that he just talked.
Oops. Oh, she can't lay foundation for the other photos because she doesn't have a photographer here to testify. Oh, good Lord.
About. The witness did not take those photos.
No,
You did not take those.
no.
Then where's the testimony about who took the photos?
They were by a professional photographer who takes photos for listing a home in the real estate MLS.
Where are they?
He has a job. I can't afford to pay him to be here. And you don't allow Zoom testimony. So, I mean, I'm doing the best I can, sir. I don't have any money.
I tell you what. You did not make a request for that Zoom testimony,
I did.
and then
I
are you going to keep it from me? Because I'm not going to do this all day. The person that took the photos needs to testify as to those photos preliminarily.
I did not know that, sir. But if he could do Zoom,
Then that's not my issue.
Yeah, no kidding. We know you didn't know it. We know damn well you didn't know it. He's not confused on that point.
I'm telling you. Yes,
I requested Zoom for 4 other witnesses and I was denied because they live out of state.
because this individual did not consent. You should have at least asked her.
She doesn't talk to me outside of court.
You know what? I am not here to solve the world's problems. Only the issue that's in front of me. Did you make the request of her to have these?
She doesn't, I sent an
Did
email.
you make the request?
No,
Okay.
but she does not talk
That's
to
an
me.
answer to my question.
He can at least attest to the fact that the home was in good shape before she took it
I
over.
think he already told me.
Okay, that's fine. Mr. Clinton, can you please confirm that the MLS photos are the same photos that accurately represented the pristine and spotless condition of the property presented to Ms. Lyman? The home was in pristine condition when it was
Pristine and spotless. I mean, it may have been or may not have been, but it's just whatever.
presented to Ms. Lyman. Okay. Can you confirm that the broken screen door, oil stains, changed front door lock, security camera, broken master bedroom blinds, all occurred after Ms. Lyman took Tennessee?
Yes.
Son, how often were you at that property?
Before or now?
Before. Well, let's just ask this. How many times have you been to that property?
Or under 10?
How many times before Miss Lyman moved in?
How many times? What's it?
Before Miss Lyman moved in.
Oh, about 50 or 60, not more.
And you've been out to the property since.
Yes, I have.
For what purpose?
Pick up the mail or,
For who?
for,
What's your relationship to Miss Anderson?
start, well, we've been friends for about 20-some years.
What is the relationship now?
We're still friends.
Just friends?
That's right.
Go ahead.
He handles the cock for her.
Mr. Clinton, were you present in the district court on August 15th when Miss Gloria Vanderwell testified in front of Judge Washington regarding 6285 Maplehurst Drive?
It's hearsay. Don't answer the question.
Did you see photos showing 2 bathtubs with running water left?
Where? Did he see photos where?
In Exhibit 6 that show the damage she did to Miss Lyman did to the Maplehurst property.
They were
To whose property?
to miss her prior residence. He's seen the damage to her prior residence.
Were you there and saw the damage? I'm not going to allow it.
Even though it was in court that it was presented?
What did I just say?
Okay, okay. Okay. I'm learning, sir. Forgive me.
Not fast enough.
Okay.
I mean, all of Judge Simpson's rulings and everything makes sense. This is sort of the way it would go in front of any judge. I give him a hard time about being pro-tenant, which he is, undeniably. But this sort of crap, and then the judge getting tired, and then helping the pro se's is what happens every effing time. He's not out of the norm with that. And to the extent that he is chiming in, all of that legally makes sense.
Did you see the final water bill from Ypsilanti Township showing a final water bill for the Maplehurst property of $3,153.69 during Miss Lyman's tenancy at 6285 Maplehurst?
Why am I talking about Maplehurst?
I thought it showed evidence of damage to prior property.
I don't.
All right. So now we haven't had leading, although it was all leading. He was letting that go. But he has now made a hearsay objection and a relevance objection. They were correct. They were good objections, but but I'm just saying he's making them from the bench, which by the way, he can do. There's nothing wrong with that. It's just, it opens you up to, are you doing it for both sides?
Have you ever been to Maplehurst, sir?
No.
You know the owners of Maplehurst? Do you know anything about that property? Other than that was a bad question. Do you have personal knowledge of anything regarding that Maplehurst property?
Okay, so
I can't testify as to.
okay, I thought because he was at court, I thought he could do that. So, okay, there's no further questions from Mr. Clinton.
Any cross-examination, Mr. Swan?
Fantastic.
Any questions you have for him? No? Thank you, sir. You may step down.
That was
And he's also Air
craptacular.
Force, sir.
Her getting him to testify that the property was in good condition before she moved in, and then crappy condition after she moved in was relevant, on point, and helpful. Everything else crashed and burned, but I will give her that. She was awful, but at a bare minimum, she got that in. That's true.
I'm sorry, your army.
On the upside for the ladies, Mr. Allen is here, so it's all good. For the fellas, well, we're screwed in this circumstance. I mean, nothing.
What are witnesses?
Miss Lyman?
Lyman, come on up. You may.
Oh, here we go with the tallest midget competition. Let the games begin.
Okay, this is going to be questions about the lease. To Ms. Lyman. Which
Ask a question.
I have a copy here if she needs it, but rent, let's see here. Rent under your lease is due the 4th of each month, correct? Per line item number 41 of the lease.
It has 2 different dates on the lease report.
Yeah, but the 4th is it.
Let's start with, do you have a lease? With whom? When did it start? I'm going to show you what's been marked as exhibit, A. What is that thing? Is it your effing lease? Okay, let's turn your attention to this here part. This is giving me hives. I'm going to get a claw.
It doesn't have the 5th. It has the 4th
Now.
on line 41. I can show you. It doesn't have the 5th. It's due on the 4th. The lease provides only a 3-day grace period and imposes a $150 late fee on the 8th day, correct? It's line number 40, line number 4 on the lease. Isn't it true that you were late paying rent for July, August, and September?
I paid the rent to the court.
I know, but you were late on those days that you paid the rent. July, in fact, on the ledger, I can give the dates when I turned them in.
What?
On July, for July rent, you turned it in August 1st. For August rent, you turned that in September 2nd.
Okay, we started with the question, but now we've moved to testifying.
And you still haven't turned September rent in. So wouldn't you agree that you've been late on paying rent all 3 months? Are you aware that partial rent payments are not accepted under this lease?
On the lease, she said I can deposit a check into.
I'm partial, meaning like you couldn't just pay half of it one day and half of it the other. It all has to be paid at one time. Are you aware that if rent and late fees are not paid, I plan to issue a 7-day notice on the 5th day of the month and file with the court on the 12th going forward, and you will be expected to pay court costs. If I have to bring you to court to get rent.
This is painful for Judge Simpson too. I mean, that question is so objectionable on so many levels. And Judge knows it, but he doesn't want to supply every effing objection for her, to his credit. So you're just cringing inside.
If I file a 7-day notice.
Was that a question?
No, I'm making her,
Question?
no, I was making her aware of that.
You need to ask her a question.
Okay,
She actually did ask a question, but it was speculative and called for a legal conclusion and all sorts of other problems.
are you aware that if rent and late fees are not paid, I plan to issue a 7-day notice on the 5th of the month and file it with the court on the 12th going forward, and you will be expected to pay the court cost.
What's the relevance?
That's just,
Question.
it's a question just to
What's
make
the relevance of that question?
that it going forward, if she still remains my tenant, I plan to be on top of it as far as rent. If it's not paid, I will issue a 7-day notice.
What bearing does that have with anything the court has to decide today?
Okay, sorry. Strike that one.
Spoiler alert, the answer is nothing.
Under your lease, only you, the named tenant, are permitted to reside in the home without my written consent, correct? Okay, who is currently living at 4259 Shandy Court? Isn't it true that you're
That is a relevant question and reasonable. I'm shocked. Now I'm shocked that she'd said anything remotely okay. That is a reasonable question. It's relevant to the issues before the court today. We already know the answer, but you wanted to elicit that in testimony during the trial. I'm about to fall over.
uncle and 3 children have been observed living at the property by several neighbors?
No, just because somebody seen people come over doesn't mean that.
Okay, line items number 19 and 9 and 19 on the lease. Did you change the locks on the home without my written consent?
I told you I was lease agency.
Without my written consent? Did I write something down?
No, no.
Okay. Are you aware the lease prohibits changing locks without the landlord's permission and expressly allows the landlord entry without notice in emergencies?
Security system.
Do you know that I'm able to go in emergencies? Fire, water?
Yes.
Okay. In an emergency such as water running continuously, fire, or a suspected medical emergency, do you expect me to break the locks to gain entry?
Oh, yeah.
Are you aware that my former tenant, Gabriella Anderson, died in Ypsilanti Township?
What's the relevance of that?
I have a history of a tenant dying in my property.
Why do I need to
That's nothing to be proud of, Russ. Oh my God. Oh my God. Make it stop.
know that?
Because it shows why it's important to have access to a home. As a landlord, if somebody dies, I need to have
Does
access
she
to the
know
home.
that? And if she does, what's the relevance of that in whatever her answer is?
I'm making her aware that the reason why it's
This is
important,
not a proceeding for you to make her aware of things or what your expectations are.
okay. I was explaining,
You don't have to answer the question. Go to
It did succeed in making you look like a terrible landlord. I'm just, if that was your aim.
your
Okay.
next one.
okay. Will you allow my licensed contractor, Affordable Dry Basements, to enter on October 2nd to repair the basement crack?
I don't know anything
That's
about
basically it.
a license contract.
I sent an email to you at Armani Lyman.
You send a lot of emails, so I most likely didn't see it, but that's not a good day.
Well, I can,
That they could come in the spring, so.
yeah, but I don't want it to go through winter. I don't want it to go through winter. The crack is just getting worse, sir. I want to get it done before winter because they can't.
You're kidding me, right? You guys did this with AII just to irritate me. The crack. Yes, the crack. And I mean that in the most immature way possible. The crack is getting worser. That's what she said.
Going to ask a question.
I want to ask her when I can schedule Affordable Dry Basements to enter to do the repair in the basement. Are you aware that it won't pass certification with the crack in the basement? It won't. It's leaking now, sir. So we won't pass the certificate.
Why are you talking? You were supposed to be asking questions.
Okay, when will you allow my,
It got worser. It really did. Oh, shit. I was just so wrong. This organization's called Dry Basements. Shit. Oh, that's all we need around here. We'll fix it right up. We'll fix it right up.
licensed contractor to repair the crack in the basement? Okay, what month? So I can. Can I ask a question, sir? Of you? Because the crack is getting worse and it's damaging my property. It needs to be
That's a
repaired.
statement.
It needs to be repaired.
That's another statement. What's your question?
My question is, I need to, my lease states that I can go in and make repairs with a 24-hour notice. So she's going against my lease by not allowing me to go in.
Okay, once again, a statement. You asked, can I ask you a question?
So can I ask the court to enforce my lease? Can I ask the court to enforce my
You
lease?
can ask the court to do whatever you want. Whether they do it or not becomes a whole other issue.
Even though it's damaging my property.
That's the point of this whole hearing, Jack Wagon. You just don't know what to do. Get an attorney.
I'm just,
Next question.
okay. Well, it was along with, that was,
Okay.
I'll go to the next. Okay. Under the lease, you're responsible for paying all utilities, including water, electric, correct? Okay. Have you paid the water bill for May 5th through August 31st, totaling $1,471.87?
I'm sorry, say that again.
The water bill is in my name. I have worked something out within my name.
Okay, because may I make a comment to the court? If the water bill,
Ooh,
okay,
this is testimony.
okay. Did you pay the DTE bill that was subject to shut off notice dated on September 17th? Yeah, as a landlord, they sent me a shut off notice.
Oh, for Pete's sakes. Why do I keep getting comments from you and not questions?
Okay, the question was, did you pay the DTE bill that was subject to shut off?
Answered.
Did you paid it?
Yeah.
Did you pay the electric bill? So the electric's off?
That has to do with you.
Okay. This is the next question. Do you plan to keep the home above 50 degrees this winter as required by the lease? Okay. Are you aware that you will be held liable for any frozen pipe damage beyond your security deposit resulting from temperatures below freezing or winter shutoff? Huh? Thank you. Line number 18 of the lease, repairs due to tenant's negligence. Are you aware that repairs due to your negligence are your responsibility? Will you arrange for the repairs of the torn screen, broken blinds, torn down insulation and oil stains in the driveway by a professional contractor?
Supported the following installation has been put up. The screen is on the checklist. The blinds will get fixed. And the oil stains are barely invisible.
But they're still there. So it will require,
Is that a question?
well, so she's,
Just gonna argue with her.
okay. My next question was, if you do not hire your own licensed contractor, will you permit my contractor to complete the repairs and reimburse me? Okay. Are you aware that these repairs must be completed before the next Pittsfield Township rental inspection, May 26, to maintain certification? Thank you. Inspections and smoke damage. Are you aware that smoking is prohibited in the lease?
Yes.
Okay. Will you permit monthly inspections by the landlord with a witness present so landlord can document the condition of the home, including photographs and checking for smoke odor? Are you aware in the lease it says that I am allowed to do inspections with a 24-hour notice? So you don't want to go abide by the lease?
That's But she doesn't have to answer that.
Okay. Do you understand that if smoke odor is detected and smoke damage is documented, repainting and remediation of the entire home may be required at an estimated cost of approximately $10,000?
What, really? Where does that come from?
3,000 square feet will cost.
Where does that come from?
I'm just making her aware about smoke damage.
Why?
Okay, sorry, strike it.
Where
Strike it,
does
sir.
that come from?
I've been quoted $10,000 to paint that house.
By whom?
Contractor, because it's a large house and smoke will sink into the paint.
I don't know anybody named Contractor.
Nicholas Blake, licensed
Is
contractor.
he here to testify?
No,
Then I don't want any questions about any quote he's given.
okay,
That's hearsay.
okay, sorry,
Next
sir.
question.
Yes, sir. Nuisance and children, line item 20. Are there 3 children residing at the property? Okay. Were those children left unsupervised in the street on or about May 22nd, prompting a CPS call? They were supervised? I don't know if you'll allow this question, but do you understand that the lease prohibits public nuisance and requires you to supervise children? Okay. Cameras and alterations, line number 20 on the lease. Did you install an exterior camera without written consent of the landlord?
Yes, but I did tell you I was in it. And also the first court date, you said you had no problems with the cameras, so what's the problem?
I didn't authorize installation. I never said I didn't. No. I just said, oh,
She did.
the prior court date, I said as a compromise, I would accept it, but I'm just going over what she violated. I thought we
Okay, so
wanted,
she installed cameras,
Okay,
she
okay.
installed the security
that's
system.
all I wanted,
All
just get
right.
confirmation.
Ask a question. It's not time to argue it.
Are you, okay, can I ask this question?
I don't know.
I know I'm upsetting you. I'm sorry,
You're
sir.
not upsetting me.
I'm not a
You're
lawyer.
wasting my time,
Okay.
but you're not upsetting.
Okay. Are you aware you will need to refill the holes and repair the siding damage by that occurred when you installed the camera when you leave? You'll have to do those repairs, fill in those holes from the camera.
Under the terms of the lease, she has to restore the premises back to a reasonable condition as she got it. I think everybody knows that. Do you understand that, Ms. Lemon?
Yes.
Thank you.
Thank you,
Next
sir.
question.
I think I've already asked about smoking. Okay. And you don't, okay. Are you prohibit smoking? She knows that. Okay. Yard and maintenance. Are you responsible for mowing, trimming hedges, watering plants, and snow removal under the lease? Line item number 24.
Yes.
Okay. Have the hedges been trimmed as required by HOA rules? Do you plan on getting them trimmed so that I don't get a fine from HOA?
Have you gotten a fine?
Not yet, but they've said,
Okay.
okay. Oh. Vehicles, did you have 2 inoperative and or unregistered vehicles on the property? Okay. Were 2 of those vehicles towed away? Okay. Did those vehicles cause oil stains in the driveway? Okay. Do you plan on hiring a professional contractor to remove these oil stains?
Upstairs are really there.
Subletting and insurance. Are you currently living at the home by yourself? You already answered that.
Yes, that's okay.
Have you sublet any part of the home to another person? Are you aware that subletting the home is prohibited without written consent? Do you currently maintain renter's insurance as required by the lease?
Yes.
Okay. On May 5th, 2025, rental application, you listed your current address as 9090 Arlington Drive, correct? Okay. At the time, you were actually residing at 6285 Maplehurst Drive, where eviction proceedings were pending, correct? You were residing somewhere else that you didn't put on the application as your current address. No, it said current. Because you were being evicted, I based my decision to rent to you based on 6285 Maplehurst. They started eviction proceedings in January of 25. I was not made aware of that when I rented my home to you.
Oh my God. You got her to say it. Now argue it later, dummy. How many times can we have the same freaking mistake? I don't care if you've never done it before. Figure it out.
Did you disclose that the pending eviction of your true address to me before moving in? Did you disclose that address to me before moving?
Was she required to?
Yes, the application said, where's your current residence? So I could follow up with the landlord of that residence.
That was not your question. You asked her whether or not she disclosed an eviction.
Yeah.
On the application, does it indicate, have you been evicted?
Yes, there's a section in there, any prior evictions on the application.
All right. At the point in time she applies, has she been evicted?
There were eviction proceedings.
Is that what the question asks?
No, it says, have you been evicted?
Thank you.
Oh, sir,
So that case had not concluded. Is that correct?
that's correct.
Okay. Then if you're saying that she misled you, your question is bad.
Well, but
As it has been all this morning.
okay, but she didn't disclose where her
You want to
address
argue
was.
with me?
No, honey, not.
Her questions, an attorney could get this done in 5 seconds. She absolutely committed fraud in the application process. She absolutely changed the locks. She's absolutely violated the lease in 1,000 ways. But this woman is so incompetent and frankly offensive that nobody cares. But even if you do care, you can't get there because she doesn't get anything in as a matter of law.
I'm sorry.
She doesn't have to answer that question. Or actually, she answered the question.
Okay. Are you aware your lease states that breach of the lease gives the landlord the right to repossession? Line item number 32. Are you willing to remedy the lease violations or return the property to me? Okay. Do you understand line item number 36 on the lease? Only written agreements signed by both parties are enforceable under the lease. So verbal doesn't mean anything. It's only written.
You answer that. Okay. Thank you.
This is questions with regard to the lease application. Miss Lyman, are you aware that the phone number you listed on the lease application, 734-460-9043, is that correct?
I listed that number back in 2023.
No, on the application you just gave me, in 2025, we have that number on the application. Okay. Are you aware that according to reverse lookup, that number is this number is registered to you, but I've never received a response when texting or calling you on this number?
So, okay. If she says yes to that, what's that mean?
Okay. Okay. Scratch that one. Okay. Isn't it true that the only way I have been able to communicate with you is through your mother, Joanna Lyman, at 734-465-8335? Okay. Please confirm, do you regularly monitor or respond to your phone you listed on your application? Well, I guess that would be no, because you.
Well, are you going to answer it or are you going to let her
Okay.
answer?
Okay, sir. Sorry.
It's fine.
You just make a lot of mistakes.
Okay, so so the number of 734-465-8335 is the best number.
Yes.
Okay. Okay. On your application, you listed your current address as 9090 Arlington Drive, correct? Current address. Okay. Isn't it true that at the time you completed your application, you were not living at 9090 Arlington Drive, but at 6285 Maplehurst? But you were living at 6285 Maplehurst. Okay. Isn't it also true that you were being evicted from Maplehurst property owned by Miss Gloria Vanderwell, your former landlord? She's the owner of the property. Greg is her husband. Yeah, that was the person that was at the prior trial. Yeah. Okay. On your application, you stated that you were renting a room from your parents, Desmond Jones, at $500 a month, correct? Well, it's on the application. It says Desmond Jones, and you told me you were living with your parents. Okay. But on the application, it says you were living at 9090 Arlington and paying $500 a month to your family. That's what the application says.
Yes.
Okay. You also wrote that the reason you wanted to rent my home was to have a place of my own, correct? Okay. In reality, weren't you leasing your own home at 6285 Maplehurst at the time and facing eviction for non-payment of rent and property damage? The question is because you falsified the application, so you committed.
That's a conclusion.
If she said her current address was 99.
It's a conclusion. Get to your next question.
Okay. Do you admit that the address you provided on your application was false? Do you understand that providing false information on rental application is considered fraud?
Well, don't answer that. That's a legal conclusion, right?
I've been doing my Google searches, sir, and this is what I.
Well, then bring Google.
Is she typing all this, sir?
But ChatGPT said that. The judge is absolutely right. It's calling for a legal conclusion. You're almost there, but not all the way. And it's just, and you can't ask you've got her to say she provided false information. You later argue that constitutes fraud. You don't have the witness effing say it.
Was I given?
You know what?
I'm just asking.
You know what? You know what? I'll tell you what. I'm taking a break. You get your questions in order, and you understand how to address this. Am I clear?
Yes, sir.
Have a seat. You may step down for just.
The District Court, County of Washington, State of Michigan, yeah, I heard Judge Day said so.
You may be seated. Ms. Lyman, why don't you come on back up?
I hope at some point we convert to trial by combat because that'd be fun. All I'm saying is if the tenant ever catches the landlord, she wins.
May continue
There's
your
no doubt in
question.
my mind.
Thank you, sir. Um, Do you admit that the address you provided on your application was false as your current residence? Do you understand that providing false information on rental application is considered fraud?
You already asked that.
Oh, I'm sorry, sir. I
Strike it.
forgot where I was. Was I given truthful information to conduct my due diligence as a landlord, or did I base my decision to rent you on falsified information?
She's not going to be able to answer that. That's in your mind.
Okay. Sorry, sir. Your driver's license issued in 24 showed 9090 Arlington Drive as your address, correct? You were actually living at 99 Arlington Drive when your driver's license was issued, or were you living at 6285 Maplehurst? Do you acknowledge that listing 9090 Arlington as your address misled me about your true living situation at the time? Do you understand that I relied on information you provided in your application when deciding to rent to you? Are you aware that had I known about your prior rental history of fraud, non-payment of rent, and property damage at Maplehurst, I would not have rented my home to you?
She can't answer that. That's you.
Okay. Would you agree that my decision to rent to you was based on information you provided that was not?
She can't answer that. That's you.
Okay.
As to the form of your question.
Ms. Lyman, are you aware that Mr. Diop Dimba has owned and lived in 9090 Arlington Drive, Superior Township since December 21? You and your family rented the property from the previous owner prior to December 21, correct?
Rented what?
9090 Arlington Drive?
All right, you can answer it. Forward it to us.
No, you didn't rent it? After Mr. Dimba purchased it, you did not live there, true? Okay. Your driver's license lists 9090 Arlington Drive, Superior Township as your address, correct?
You already asked and answered. Don't answer.
That driver's license was issued July 16th, 2024, while you were living at 6285 Maplehurst Drive in Ypsilanti Township, correct?
Don't answer that. Ask and answer.
Did you have permission from Mr. Dimba to use Arlington Drive on your driver's license or rental application? Okay. Did you use Arlington Drive to mislead me, the landlord, into renting my property to you?
That's your previous address. I gave your previous address. I don't know. Reach me with.
I asked for a current address on the application, not a previous.
Neighbors or 99.
Did you knowingly provide false information to gain advantage in renting my home? Okay. Are you aware that using someone else's address without permission is considered fraud under Michigan law?
No, she can't answer that. You're asking for a legal conclusion.
Did you understand that this could lead to criminal or civil penalties?
She can't answer that.
Do you admit your use of Arlington Drive was unauthorized? Okay. So, Ms. Lyman, even though you were living at 6285 Maplehurst in Ypsilanti Township, your driver's license issued July 16, 24, and rental application listed 9090 Arlington Drive, Superior Township without permission to mislead me into renting my home, correct? Ms. Lyman, oh, sorry. Ms. Lyman, can you explain why the following damages are present after you took occupancy? Broken master bedroom blinds, oil stains in driveway, broken rear screen door. We already know about changed front door locks and mounted exterior camera, but what about the broken master bedroom blinds, oil stains in the driveway, and broken rear screen door?
The rear screen is on the check. Well, I'm in the way.
Okay, so you're going to replace the blinds eventually, or? Okay, thank you. Are you aware that under paragraph 18 of your lease agreement, you were responsible for these repairs? Okay, I just, Ms. Lyman, your tenancy began on May 5th, 2025, correct? Are you aware that the property had a valid certificate of occupancy and issued May 2025 before you moved in? Do you understand that a certificate of compliance means the property passed all required inspections and met township standards at that time? Are you aware that of the email from Mr. Frank Daniels, which I forwarded to you, Ypsilanti Township Housing Inspector, stating that the torn screen, torn insulation now present?
Ypsilanti Township?
Pittsfield, I'm sorry, sir, Pittsfield Township. Torn screen and torn insulation would not have passed inspection May 2025. So based on the inspector's statements, those items were not present at the time of his certification, correct? So those damages occurred after you moved in. The screen door was not on what checklist? The screen door was not, that screen door was not like that. That Mr. Daniels.
Is that a question?
Yeah, the question was damages occurred after you moved in. Because Mr. Daniels states that the screen door in that condition would not have passed inspection.
What's the question?
Proof of condition that we got.
What's the question?
The question is,
Keep making statements and not.
therefore, the damage occurred after you moved in, correct? Because Mr. Daniels inspected the property and it passed. Then she moved in and he said it would not pass. For the screen door.
So what's the question?
Just her acknowledging that she'll repair it in due time.
She already said that she
Okay.
was gonna do that.
'Cause we
I
won't-
mean, and if she doesn't, that's part of the reason you have a security deposit.
I know, but the problem is when we get the inspection next year, it won't pass with these items.
Okay, and then I don't know how you see into the future.
Okay, I'm just trying to cover all my bases, sir. Sorry.
I just want to say that I never said that I would compare the screen door to it was on the checklist.
The screen door was.
I
not on the
heard
check.
you.
So you're not going to repair this?
I'm off the screen door. If she says it's on the checklist and you're saying it's not on the checklist and there's damage to that, that's going to have to be dealt with at some other point. It's not to be dealt with here. She's answered the question about the screen door. Go on.
Okay. You signed a lease that includes section 18, which states that tenant is responsible for damages and repairs caused by tenant during your tenancy, correct?
That's asked and answered.
Okay. Are you aware that the torn insulation violates property maintenance code section 102.2? Are you aware that the torn screen violates property maintenance code section 304.14? Do you understand that property cannot pass inspection next year, May 26, unless these repairs are made?
It's irrelevant. Irrelevant. Next question.
Okay. Do you want to maintain your tenancy at this property?
Yes.
Okay. Are you aware that to maintain tenancy, the property must be recertified May 26th and these repairs are required to pass?
Go ahead and answer that if you can. It's not going to matter to me.
Okay. So, Ms. Lyman, to summarize, the property passed inspection and received a certificate of compliance May 25. You moved in on May 5th, 25, and the torn screen insulation would not have passed inspection. They occurred after you moved in. They violate township codes, and under section 18 of your lease, you are
Is
responsible.
there a question?
Okay. Ms. Lyman. Okay, accountability and lease compliance. Ms. Lyman, do you see that as a tenant, you are responsible for ensuring that all occupants, including guests or family members, comply with lease terms and local laws? Do you see that having unlisted occupants and unsupervised children could put the property of the residents in your tenancy at risk?
No.
Unsupervised children?
Yes.
They were running in the street, sir, and the neighbors complained that they almost hit one.
Then how does that put her tenancy at risk?
Oh, I thought it,
You have children? Okay, so hold on. So I don't even understand where that question might even go, given the great benefit to the question.
there was a police report that kids were running around unsupervised and CPS got involved.
Okay,
And I provided that to the court.
and so what does it matter if they're not her kids?
Okay, I'm not a lawyer. I'm trying my best, sir.
I can see that you're not a lawyer.
Forgive me.
I gotta ask you a question. I don't know
Okay.
how you're attempting to try to hold her responsible if that aren't her, if you haven't even established her kids that are a guest of her.
Okay, okay. Appreciate that, sir. Okay, Ms. Lyman,
Thanks for the
do
tip,
you,
Judge.
I sent you a copy of the HOA vehicle policy for the neighborhood. Are you aware that the policy states that unregistered or inoperative vehicles are not permitted on the property?
You were last on the property, did you see?
No, I'm just,
Are there vehicles on the property?
no, this is,
Then why
okay,
are you dealing with?
okay. Okay. And you said it's hearsay about Maplehurst, so this next exhibit was all about Maplehurst. So you're saying that that's hearsay?
Ma'am, I don't even know what you're talking about.
Her prior residence, that was this next section, the damages to her prior residence. And
The
that's,
damages to a prior resident, I don't know why that would be relevant to me. And I don't also understand that, I don't even understand how you're getting that in.
well, I just thought showing a history of destruction is relevant to my house and me being concerned. It shows why I'm concerned about my property. I'm not just concerned for just to be concerned. I have a reason to be concerned about my property. That's all. I'm just, this is my $570,000 baby. I care about my home.
Anything else?
Oh. So section 6 is off there. So that's it for questions. I wanted to go over section. I had something for the court, but I'm done with asking questions of Ms. Lyman.
All right. Ms. Lyman, you'll have an opportunity to testify. You may step down. Any other witnesses for the plaintiff?
No, sir.
All right, here's what I'm gonna do. Ms. Lyman, prior to your opening your case, should you decide to give one, court's gonna stand in recess and it will go ahead, you can go.
Do I sit down, sir?
Pardon?
Do I sit down, sir?
You can sit down if you want.
Okay, well, you're the
That
boss.
was
I know. You
really
ought to remember that.
just awful.
I was gonna wear a hat. I love Judge Simpson.
Here's what I'm gonna do. I'm gonna break for lunch. It's a little bit early, but I thought we might get somewhere this morning. I'm gonna break for lunch. We'll reconvene at 1:00. And then if there are no other witnesses for the plaintiff, then we'll go to defense's case at that point in time. All right? 1:00,
Thank you, Judge.
not 1:30. 1:00. Okay? Thank you. Court stands in recess. Come to the stand and be sworn.
Take a seat, raise your right hand. Do you solemnly swear to affirm the testimony? State, spell your first and last name, record, please.
Go ahead.
Oh, how the turntables have turned.
Is it true that you told me Ivory Clinton was your domestic partner? Is it true that you have been showing outsiders pictures of me containing my personal information?
Wait, what was that first question?
Is it true that you gave me verbal consent that I could get my $750 decline deposit back?
If the house is in standard condition, cited.
Is it true that a prior tenant is also suing you for their $750 decline deposit?
No.
May I get a written
She sucks, but she's slightly better than the last one.
addendum of me getting my $750 decline deposit back? Why not?
Because it depends on if you leave it in the same condition as I got it. If it's spick and span claim, that's going to depend on how.
You said verbal consent doesn't matter, so I'm asking you, can I get written?
Deposit back if it's not clean. If it's clean, then
So I'm asking you.
I'm good at that. It has to be clean.
May you write that I can get my $750 deposit back?
If it's kept clean, same condition, like floors are clean.
Can I just stop here? The $750 is listed as non-refundable, but you are indicating that it's refundable provided the conditions are,
To my satisfaction.
well, ma'am, is that what you're saying? That is not what you're saying? You're saying that it's still non-refundable?
It is dependent upon conditions to the lease.
Understand what I'm saying. At this point, you want to know what? You interrupt me, we're going to have a real issue.
It's about to get worser.
There was a notion that the 750 was non-refundable, meaning it didn't matter what Ms. Lyman did. What I'm hearing at this point is that it is refundable. The conditions of that refund will wait to some other point in time, and there might be further litigation regarding it.
Yes, sir.
Is that what I'm hearing? Ms. Anderson?
That it's conditional return
I don't know what that means.
if it's left clean, like the toilets are clean, the bathroom.
Okay, understand something, what I'm saying. The cleaning deposit, if it is non-refundable, which would create some other problems, that means irrespective of what it looks like or what Ms. Lyman does, the 750 does not come back. A refundable cleaning deposit means that I have the 750 and that 750 would be returned provided it is left in a clean condition.
The same condition I gave to her, meaning I don't have to hire someone.
Ma'am, I'm telling you what. Your interpretation of landlord-tenant law is going to get you in trouble. I think I've got it, Ms. Lyman. You can go on to your next subject matter.
Okay. Is it true that I have not been able to enjoy my home due to you continuously harassing me?
No.
Is it true that you have the neighbors watching my home? Is that not what you stated inside text messages?
No.
Okay.
You did not say that you had people watching your home, Miss Anderson.
And was I said to watching the home?
Let me just ask this. Did you tell Miss Lyman that you had people watching the house?
Ever since the incident with,
Not my question. It's not a qualified answer. That's a yes or a no.
yes,
Then why did you under oath just tell her no?
well, they're currently not watching the house.
Well, that's not what she asked you. Why are you changing the answer that you just gave to Miss Lyman? No, I want to know why you changed it. She asked you the question.
If
You told her no. I asked you the question. You told me yes, you said it.
people were looking at, okay, I guess I'm just, right now they're not looking, before they were.
Oh, that is not what she asked. Go ahead, Ms. Lim.
Okay. Is it true that you have parked down the street stalking the house
In the past, yeah, when I was trying to get evidence for the court.
and popping up on places where I have been? Is it true not only do you talk about me through text messages, you CC other people in my email that has nothing to do with them tarnishing my name?
Every all the witnesses who have told me things, I try to do them. But I'm not trying to shame.
What does that mean? What do you mean there are emails?
Like she emails a whole lot of stuff and put people from the neighborhood that I don't even know or people that I never met in the emails of her saying certain stuff to me and falsified information on me.
Miss Anderson, do you do that?
I've heard emails, including the neighbor, yes.
About Miss Lyman?
Yes,
Why?
because they're telling me they're concerned about kids running on. And there
Was it only about the kids?
was no.
No, in email, she has stated false things like crack pipes, that there's a rapist in the home, different stuff like that.
Did you, hold it. And I'm just going to remind you, you're under oath,
Yeah.
under penalty of perjury.
Yeah.
Did you say things that directly indicate that there may be drug use
Yeah,
and or a rapist in the home?
yes, because when I looked up this, you know, Mr. Lyman, he had a criminal history.
You emailed Miss Lyman, which are her neighbors while she's renting,
Because they were saying,
indicating that there was drug use, particularly hard drug use like crack, and that there was a rapist at the
I
home.
said a potential somebody with a criminal history.
Did you say potential?
Yeah, I did. I said, is this Mr. Lyman, who was named Augustus Lyman, who lives there? He has an extensive criminal history.
Why?
Because I wanted to alert the neighbors, so that.
Alert them of what?
That they, I don't know who's living there. I didn't do a criminal background check on this person, and so I had to look it up online through ICANN. And this particular uncle had a rap sheet. And I think
Was the address listed? Miss Lyman's address?
no, the uncle, but I did it.
Fine, but was the address of that individual list, was it Miss Lyman's address? I don't care what you were told. Was the address, when you looked it up, was that Miss Lyman's address?
I don't know what Miss Lyman's address, it wasn't under Miss Lyman's address, it was at the uncle. I looked up the uncle.
I just want to state that that is
No.
my uncle.
When you look up, if it is a sex offender, you will have an address that they are registered to.
It wasn't.
Was he registered to that address?
Sex offender, it said attempted sexual assault under Augustus Lyman. He had that when I looked him up online, he had a big rash. So,
And you sent that to Miss Lyman's neighbors?
yes, because they were concerned who was living there and what's going on.
Court's been recess.
Well, Ron,
Fine.
Recording's done.
All right, that's good. Yeah, we're good. Can you find them, please, sir?
Oh, we have miles to go before we sleep here. I told y'all from the beginning of this channel, being a judge is a crappy job. Nobody believed me. But I know of what I speak.
We're back on the record in the case of Anderson versus Lyman. Ms. Lyman, you may continue.
Is it true that you gave me verbal consent to get ADT?
I gave verbal consent, yes, but that was not the honest now, the version of locks changed. That was for sensors in the inside. I was not told about door locks for parents.
Is it true when we first started going to court that June rent was already paid?
June rent was paid late, but it was paid, yes.
Is it true that you have called the Pittsfield Township Police Department on multiple occasions presenting falsified information?
No, when I get a hold of you and I'm concerned about what's going on, I call them and you don't respond.
So are you saying?
What? You call her, she doesn't respond, and you call the police.
I text her, I just wanted to see my property and not having a response. It's not, again, I'm not able to see.
You call her, text her, whatever. You don't get a response, whether she's choosing to or not, and you call the police. And what did the police say? I mean, what do you say to the police? Oh, for Pete's sakes.
I just want to state, not only is it a wellness check, when the police come, they had told me she must have something against you. They don't be feeling like coming out because it's always something, and they say it comes from her.
Go ahead. Stop.
Is it true on multiple occasions I asked you to stop sharing my personal information?
You said that don't you let her get one emails, yeah.
Is it true on multiple occasions that I asked you to stop sharing my personal information?
She asked you, and yet it still got worser.
Then why do you still do it?
Stop putting her on emails. You told me to not do your stand at all. Only the she's involved with. Or she's involved in over the I still do this thing.
May I approach the witness, Judge? Somebody hold my hopes.
If it doesn't involve him,
Is it true that you told me that you have a multiple personality disorder along with other mental issues?
That's right. That I don't. We just
I was asking, is that the
stop.
that is
Stop. She doesn't have to answer that question. Go to your next question.
Is it true that I treat you with respect and all you do is disrespect me? Do you feel you know personal boundaries?
You don't respond to my text, so I don't know how to get hold of you.
Is it true that you're going through financial hardship? Is it true that you have stated in an email?
Is it true that you're a broke ass hoe? That's where we're going here. That's where we're going here. You know what Shirley wants to ask?
Ma'am, are you a whore?
That you will pay the water bill and that I could reimburse you?
That's how I want to get a judgment, so that I can pay whatever you want to possibly say. I don't think if I can get a judgment for you to reimburse me.
But if you're going through financial hardship, how would you pay the water bill?
Someone has to pay it. I'll get a loan, I have, a borrower, someone has to pay it, because otherwise if it doesn't get paid, it goes on the taxes.
Go to your next question.
Is it true when we met back in May of 2025, you pretended that you were a realtor and not the owner yourself? Is it true that you stated that the crack could be fixed in spring of 2026?
It can be fixed, yes, it can be fixed in the spring.
Is it true in May of 2025, I paid $3,300?
You paid bank rent, yes.
Is it true that I paid $3,300 in June?
Yes, you paid it.
Is it true that July and August rent is in escrow?
Yes, later, they're in escrow, all late.
When I paid the rent back in May of 2025, is it true that it should have been prorated $553 since I moved in after
Let
the
her
first?
finish the question before you respond.
No, our tenancy starts on May 5th through May 4th of 27, which means that your rent is due on the 4th. Your rent is due on the 4th. And your tenancy, that's how we did not leave. You don't have to start on the first day of the month.
I was asking, since it was after the first, should it have been prorated $550?
Started
Is it true that a wet basement can be treated effectively with some caulk?
on.
Your answer to that is no. Go ahead, ma'am.
Do you know Marcus Escano?
That's irrelevant,
You'll answer the question.
unfortunately.
Is it true that he is suing you for $750?
Ma'am, you are not going to interrupt the question. Go ahead and answer the question.
Is it true that he is suing you for $750, which is the same amount as the cleaning fee?
You can answer the question. You don't know? You don't know? Is that your answer to the court? Because I'm directing you to answer the question. That's not the question. Is he suing you for the $750?
I'm not aware of that, but
Go ahead, Ms. Lemon.
Are you aware of the bailiff that had came on behalf of Marcus Escano to the property and was on the phone with you?
somebody called me and I didn't know who they were, so I called them.
Let me ask this. This Marcus Toscano and the $750, has he sued you?
No.
Was there somebody appearing at the property regarding a dispute between the two?
I wasn't. So someone called.
Okay, all right. Somebody, you know what? You can play your whole word games or not. Look at her. Do you know how to spell Mr. Toscano?
His name is Lacano.
Okay. Go on with your next question while we look at it.
Okay. Is it true that you made Ivory Clinton block my driveway on July 1st of 2025? That was during the inspection. What if I told you I have video evidence of you having him do that? Okay.
You have video of him blocking the driveway?
She blocked the driveway on July 21st during the inspection, and it was on video. I can see if I can find the video where she told him to pull up and block the driveway.
Hold on. You think you have video of that?
Yes.
All right. Go ahead.
Let me guess. She didn't bring it today, though.
Next question.
Yeah. Is it true that you told me that the $600 custom blinds are not custom and that I can just take them down and present them at Lowe's?
Well, they are custom, but you can look at the manufacturer on the blinds and get the same manufactured blinds so that they
Yeah. What if I told you the last time we were here in the back room that I have evidence of you stating that I can just take them to Lowe's and that they're not custom?
You take the same one. Same, they gotta match. If it's just the brand, sorry, they have to match.
That is not what I asked. I said, what if I told you that I have evidence of us in the back room and you stating that I can just take them down and show them to Lowe's?
Same thing.
Is it true that not only have you been harassing me, you have had another attorney harassing me whose name is James Fink?
I don't know James being that someone else's attorney. He's not my attorney.
What if I have you on voice recording stating stuff that he told you?
He's not my attorney.
Then why do you CC him in all our emails?
Because he's related to this attorney for Lawyer Van, and she gave me information about Maple.
Why did you say you didn't know James Fink?
James Fink I know him as attorney for Lawyer Vanderwell. He's not my attorney.
What if I told you that I have a screenshot of you during Zoom asking who he is?
He's an attorney, but he's not my attorney. I never heard of anything.
Why do you associate?
Next question.
Okay, my last question is it true that you told me if I keep ignoring you that I might end up like your prior attendant, Gabrielle Anderson, who is dead?
So I get concerned about people dying in my house. She did die in my house. She had a heart attack.
I'm asking, is it true that you told me that I could end up like her if I don't reply to you?
That's
Do you have that in writing?
Yes.
Pardon? Was that
She
a
said it in a text message. I have printed out.
Do you have a copy of that text message?
I have the copies of the text messages, yes, but I don't have them in the room with me right now.
And your understanding of that text message is, she said, if you don't respond to me, you could wind up like a tenant that is now deceased.
Yeah, she told me she's threatened me on multiple occasions.
Oh, sweet Jesus. What?
Come on, don't say to that level.
I literally don't know what's worse. The implied the threat to off somebody, or the fact that you don't bring evidence to court on the day of trial. Not only does she not have the text, but she just said, I could find the video. And she thought it was like a really grand play that she needs to talk about it, but she doesn't actually have the video with her. Oh my God. They're just dumb and dumber. And I don't know which one is dumb and which one is dumber.
Ms. Anderson, stop. Go ahead, next question.
And that's it. That's all the questions that I have. I also want to say that I do have pictures of the property.
Hang on
That
a second.
Okay.
Paragraph 27 of your lease. Do you believe that if it's true that you contacted her neighbors, that there was the blocking of the driveway, that there was, if true, an implicit threat regarding Ms. Lyman's death, and that you're constantly going to the premises has interfered with her peaceful and use of the premises, which you coveted it in that lease to provide under paragraph 27?
I haven't been to the house probably once. I think I may have driven by. I've probably driven by once, but I have not been to the house in a long time, ever since the incident with the police coming to the house. And I was just concerned about who was
Read
there.
paragraph 27, particularly the second sentence.
I'm giving her peaceful enjoyment. I'm not over there.
You don't think in any way you've interfered with her peaceful enjoyment of the premises?
I've been concerned about the house, but I mean, if she was just communicating with me, then I wouldn't be so concerned about the house. She doesn't.
What do you think her legal obligation to talk to you is?
Well, she won't give me access.
What do you think her legal obligation to talk to you is?
Since she's living in my house, I think I have some right to have communication with who's living in my house, just so I can know the status of things. I think I have some rights. And she's the only one.
Didn't ask that. Does she have a right not to say anything to you?
So she has the right not to say anything to me, but how do I find out about the house if I don't find out about it? Since I don't have access to the house.
Do you think she has the right not to say anything to you?
I think she should at least communicate, or if she doesn't want to.
All right, Ms. Anderson, you keep going on with these long convoluted answers. Yes or no? Do you believe that Ms. Lyman, tenant or no tenant, has a right not to talk to you?
I don't believe so.
So you think she has to talk to you?
On minimal basis, just with regard to the home.
Under what legal premise do you believe that exists?
In the lease, it states that I have a right to number 18. It's, number 19, landlord's right of entry. Landlord or landlord's agent may enter the premises at reasonable times during the term of agreement. And any renewal thereafter, 24 hours notice to the tenant. For the purpose of inspecting premises and all buildings and improvements thereon, to protect, make various alterations to show prospective renters, purchasers.
I read it. You don't have to read it. You can scan it and tell me where in that provision it makes Ms. Lyman talk to you.
How do I, okay, Judge, I understand she doesn't have to.
Tell me in that provision, is there anything about that she has to talk to?
Well, it says landlord must notify tenant. How do I notify her? She doesn't talk to me. Like if I want to look at the property, 24 hour notice. How do I like make that happen without?
Is there anything in that provision that requires Ms. Lyman to talk to you?
I guess not. I just don't know how to.
Is there anything in that lease that requires her to talk to you?
No.
Then why is it throughout this entire proceeding, and based upon the testimony of Ms. Lyman, as well as what were the premise of some of her questions, are you forcing her or attempting to force her to talk to you?
She doesn't want to talk to me. So maybe that's what we have to do.
Then why are you trying to force her to do so?
I didn't force her to.
I didn't ask that.
Okay.
Why were you forcing her to do so?
I'm just a communicative person, and I always think that things can be resolved by talking. So me wanting to talk to her is just.
I agree with the judge to a degree here. However, this tenant changed the locks on a property that is not hers, and she's late in paying rent, and she violates the lease in many other ways. Now, this big dummy's not articulate enough to say these things, but there are some damn good reasons why she needs to talk to her. You can't force it in a specific phone call, but what you sure as hell can do is provide notice and then get access to your property, except for the fact that she changed the locks. So then you got to drag her into court. That's your only option.
Part of my normal way of trying to resolve conflict.
Has she told you on repeated occasions she doesn't want to talk to you?
Yeah, she doesn't like it. That's.
I don't care if the tenant says, I don't want to talk to you. If they're in blatant violation of the lease and they're destroying your property, you want to make that happen. So I agree technically with what he's saying, but I think it's a bad point. And I cannot stand this landlord. Do not think I like the landlord. I don't. But she is right in the fact that somebody is destroying her property. She doesn't know how to handle it right. But that's not the craziest. She's done lots of crazy, stupid stuff. But trying to preserve her property is not one of them.
Didn't ask that. Has she told you on repeated occasions that she doesn't want to talk to you?
Help me here. She doesn't. She doesn't say explicitly, I don't want to talk to you. She just says she don't want. She doesn't like it.
Why do you?
Honestly, I don't know what you can and can't do in that particular jurisdiction. Usually there's a provision for emergency inspection or something. And one of the things I would think is if you can document that your property is experiencing harm as a result of the tenant, then you can post notice and go over there and do it. Otherwise, people can just destroy your stuff. So I don't know the contours of how that works in Washtenaw County, but there has to be a procedure. They can't just, light your house on fire and then say, well, I'm not required to talk to you.
Then, when she expresses that, do you continue to try to force her to talk to you?
Yeah.
Yes, Ms. Lime.
I
Agreed.
just want to say that I never told her that I didn't like her. That never came out my mouth.
Okay, but you don't like her, do you? I don't blame you if you don't, but who cares?
You never met my
But
mom.
they don't want to talk to you. You can't force them to do it.
Sorry, it's just.
You can gain access to your own property pursuant to the terms of the lease. That'll probably inspire a conversation. If they aren't doing other things according to the lease, you drag them into court, which is what she did. Yes, she's delusional and out there. Again, I'm not defending her. She's absolutely nuts too. But he's very much taking neither one of they both come to this with unclean hands, and he just leans for the tenant every time. The landlord's annoying as hell and is doing a lot of things wrong, but the tenant is absolutely violating the shit out of this lease, and he doesn't see that.
Sorry.
Why would you indicate to the neighbors that there's crack use at the house?
When I went in the house, I thought I saw
Probably thought there was crack use at the house.
like a crack pipe on the iron. That's what I observed when
I'll bet there's a damn good chance there is too.
I put my notes when I lived in the house. I put my,
When was this?
I sent it before. It's been a while. I basically documented what I observed inside.
Okay, let's say you document what you. Why do you feel a compulsion to send that to the neighbor?
No, I sent the neighbors the information to know about me living there because there was concern that this uncle was living there. And when I did a background check, it looked like we had a history. And I thought it was just, I was trying to help them.
Tell me each and every fact that leads you to the conclusion that that person was living there.
The neighbors told me, especially when the police showed up, there was an uncle. And when the uncle and the kids were moving in, they told the neighbor that they were the uncle and the kids moving in. And
How did you know his name?
because I looked it up, I did a search and I did it.
How do you know that the name that you looked up in this person?
Judge Simpson, can you point out the law that says that she can't talk to the neighbors? Please point to the law that says she cannot talk to the neighbors. Let's play this game with you now. Point to the law that says she cannot speak to the neighbors of the property she owns. I assure you won't find one.
Person that you purport was supposedly moving in was the same person.
Based on the physical description of who the neighbors indicated was the uncle, and I looked up her.
Is it petty? Yes. Is it illegal? No. Is it relevant? Not really.
I kind of got her family tree nailed out from her grandma to her mom. You know,
What?
I figured out
Why would you do that?
because I wanted to find out who lived in my house. I didn't do any background checks.
Why would you do that?
I was concerned
Have
about-
you ever, with another tenant, mapped out their family tree?
I was trying to find out who this uncle was because I was concerned with the neighbors. Little kids running around in the neighborhood there.
You do understand that if you're renting property, that the tenant doesn't become your indentured servant and or slave.
Yes, sir.
And that you can't force them to do certain
In Judge Simpson's court, you become their indentured servant and slave, as you'll soon find out.
things that they've not contracted to do. You understand that, don't you?
Yes, sir. What kind of contraction look like?
You understand that because they're a tenant, you don't get the right to disparage their reputation with the neighbors? Do you understand that?
Wasn't Armani what I was concerned about. I understand though, I mean, maybe I understand that I shouldn't be concerned, but
Is there a defamation case before the court? Or is this just the judge sua sponte injecting this nonsense? I mean, I think she's a little out of bounds, but this is not before the court.
I was concerned because I just didn't know.
I didn't say that. You can be as concerned as you want.
Nervous.
Do you understand that you're not permitted to disparage her reputation that way? Do you understand that if you see or purport to see something that would be drug use like crack cocaine use, that you don't have the right to then become, I guess, the judge of what that is, what you think it is, and draw a conclusion. And
This is getting absolutely wacky as a matter of law. Absolutely wacky. She has a right to say what she thinks under the First Amendment. If you think it's crossed the line and it's gone to defamation, someone needs to bring an action and do that. That's not before you today.
then besmirch her reputation by sending that to the neighbors. You understand that you don't have a right to do that?
Okay, sir. I was just.
Don't okay me.
Yes, sir.
Answer my question. Do you understand? Then why did you
Why are you just misstating the law from the bench? It's embarrassing. Stop it.
do it?
I was just concerned. I didn't know what to do. I was concerned about a bunch of little kids running around the neighborhood and I didn't know it's in my house.
Or these little kids smoking crack? I mean, why were you tying that to the kids?
I thought it might have been crack pipe. It looked like it. I don't know.
Then why would you tell the neighbors it is? If you're not sure yourself, why would you tell them that?
I was telling them about the, I was not telling.
You didn't say anything about a crack?
I don't remember who I told about.
Did you?
I don't remember who I told about. I know.
Well, you better remember right about now, Miss Anderson. You have a very convenient memory. Did you tell any of the neighbors or intimate to any of the neighbors that there was crack being smoked in that house?
So
Not an answer to my question. Listen closely. Did you tell any?
Your question is not relevant, and it's completely inappropriate. Sorry, Judge. Move along.
Any of the neighbors or intimate to any of those neighbors that they were smoking crack in that house?
I did, yes. When I did a Google search when I got
I didn't, there's no question. Quit talking. What months are you claiming are owed?
Can I get the time?
Just this month is old.
What months are you claiming are owed?
July, August, September, plus the water bill that I already paid, $148 and 98 cents. I called Pittsfield Township before.
I didn't ask you that.
And then the two.
What months, listen to my question. What months are you claiming she hasn't paid?
July and August are in escrow, and we're waiting on September. So September is the only one that's not in escrow.
So as she indicated at the very, if she puts that in, she's paid in full.
Not utilities and not court costs.
It's late. She hasn't paid the utilities, and she's changed the effing locks. She's also violating the lease in many other ways, like having unauthorized tenants and doing all sorts of other crappy stuff. And you're minimizing that like it doesn't matter. I cannot stand this landlord. And you're still bothering me, Judge.
She's paid in full for rent.
Yeah, but she still has the late fees that you already authorized on July 11th. You authorized the 150 on July 11th.
Water bill, where's there a copy of the water bill?
Can I get it, sir?
Yes,
Thank you, sir.
and leave that lease on the stand.
Do you want me to come back up to the?
Yes. Ms. Lyman needs to see anything that's being presented to.
All right. In the prior hearing, the tenant admitted that she changed the locks. That's all you need. That's all you need. Trust me. Trust me. If you're sitting on a $500,000 property and your tenant who isn't paying on time decides to change the locks, you wouldn't like it. We want them both to lose somehow. I mean, of course, the landlord loses. We're in front of Simpson. But I'm trying to think of a way they can both lose.
Lyman, you indicated that you have been in contact with Pittsfield Township regarding the water bill.
Yes.
And have you arranged payment of that water?
Yes, I have already.
Yes, Miss Anderson.
Supervisor indicated that they had not looked at one of the water bill just an hour ago. I spoke with.
Do you know who you spoke with?
No, I don't. They just told me that we could start a payment plan up.
Pardon?
They told me that I can start a payment plan up starting next next month.
Okay, who told you that?
Someone from the water department.
I've not seen this. No. I assume the tenant gets whatever she wants because we're in front of Simpson. While they're both despicable.
How much is the current bill?
So it's $1,327.94, and then I have already paid the prior water bill, which she already paid for her part of it. Township water rate department was the $143.93.
So
I paid that already.
have you paid the water bill?
Have I paid? No.
No, not you. Miss Anderson, you haven't paid this water bill?
I paid the water bill for me. It's already.
Give me the copy of the lease that I have.
Thank you, sir.
So the only thing, Miss Anderson, that you paid on this water bill is the $143.93.
Yes, sir. I can, sir, I can pay the rest of it today.
Ma'am,
Oh, I'm
I
sorry.
didn't ask you that. I just want to be clear. You did not. You haven't set up a payment plan.
Yes, I haven't physically set up making any payment.
Pardon?
I haven't made any payments. No. I was just told that I could do a payment plan next month, starting next month.
October.
Yes.
And is there a monthly amount on that?
They didn't say yet.
Pardon?
They didn't tell me yet. Still trying to work everything out.
Well, Zane, how many times have you sent Ms. Lyman a notice to quit?
I believe just one after.
You have never sent her a notice to quit for the collection of rent.
The 30 days that I sent was because of the fraud. And it included no rent in that it was for fraud and not paying the rent. At the time, she was late on paying rent. So
Okay. So she screwed all that up. So you lose. You just lose as a matter of law. You just lose as a matter of law. There's no two ways about it. You got to have a proper notice, and then afterwards you can't accept rent. I mean, it depends on the circumstance. I don't know the intricacies of this particular place, but this is all intricate stuff, very local. I mean, it's all really simple, but like stuff you wouldn't know. You can't guess at. You just have to look it up and see what the damn rules are and follow them. And she didn't. She's screwed.
How many times have you sent her the rent or a notice to quit for non-payment of rent?
well, I think I gave you 70 notice.
Yes.
No, I didn't 70 or I didn't 30.
Have you ever sent Miss Lyman?
Yeah, most lay people do. You know, people don't understand this stuff. It's not to be messed with. I know people who handle this pro se, like landlords who handle their own like evictions and stuff, but they had to learn. It's not like oh I just own one house and I'll deal with this every 3 years. No, you'll get crushed that way. If you're operating 25 properties and you're in court on these issues, you know, 5 times a year, okay, maybe you can figure it out even without an attorney. But other than that, get an attorney.
Lyman a 7-day notice?
No. 30.
How did you calculate the late fee?
Based on Google AI, 5% is the industry standard, so $150 for the 3 years period is considered within the realm of.
Oh, sweet Jesus. Did she just cite Google AI?
In Michigan?
It's that what it says.
I can't.
Yes, 5% is the industry standard of the rent amount. We put it at 165, so I think 150 is fair. And that's
What do you think the purpose of the late fee is?
to try to encourage timely payments and also.
It can't be liquidated damages. It has to somehow or another be related to your efforts to collect
Like,
rent.
With Detroit and come here, and that is gas and time. Gas isn't cheap. My time, you know, spend days here.
Oh, shit.
I think I should work here. I just wanted to pay rent. I mean, I honestly.
I don't think there was a question.
Okay, sure. Thank you.
Let's go to the application. When she filled out the application prior to renting, did you check any parts of that application to verify any of the information?
Yes, there was a number that's no longer working. It was supposed to be her landlord, Desmond Jones, that
I was never pulling for the landlord for 1 second. What I am in favor of is the law.
Did you get a response from this Desmond Jones?
No, but I thought it was her parents, so I, she was living with her parents at 99 Arlington, so I thought, okay, I didn't, she didn't tell me.
Did you get a response from Desmond Jones?
No.
What else did you attempt to verify?
Well, since she was living with her parents, I took it as she was being honest that she was living there. She was paying $500.
Let me try this again. Did you attempt to verify any of the information that is on this application?
Well, the application showed me her pay stubs. So I knew it was through a legitimate company, rent free. And they verify information like that. So I saw the word pay stub, so I assumed that's where she works. The only thing normally I would have also done is talk to the current landlord, but because it was her father, supposedly, or her parents, I thought, I guess I don't need to talk to them since that never didn't work. And so I just didn't pursue that, talking to the current landlord. I didn't know that it was the other people that were the landlord. The Vanderbilts were the landlord, and I did not know. She would have definitely steered me away, she said.
Case dismissed. Go find an attorney and do it right next time. That's all there is to it.
So just so that I'm clear, if Miss Lyman would talk to you, let you just come into her premises illegally as you requested, would we even be here?
No, I would.
Okay, that's what my problem.
I just want to know that the problem.
The reason that we're here, is it not, is because she won't talk to you.
I'm concerned about my.
There has been nothing detrimental to that application to you, is there?
Sir,
Is there anything that has been detrimental?
Are you insane? I'm trying to be nice to Judge Simpson here. But a material fraud in where she was living, which shows that she was being evicted at the time, if the landlord is to be believed, and I bet she's right, she didn't get into evidence. And now she's having problems with her, which are probably similar to the ones that she had that were getting her evicted from the last place. And she doesn't have it into evidence. We don't need to go there, but you have the unmitigated gall to ask her if that's a problem. Hell yes, it's a problem. Is this your first day on the bench, Judge? Have you lost your mind?
To you.
I have lost sleep over this, sir.
Okay, fine. We all lose sleep. Is there anything referenced at tenancy that has been detrimental based upon your reliance on that application?
I'm worried about my property, sir. If she does damage to my property, it's going to be well beyond her $5,000 earnest money. It's going to be well beyond that. And I'm worried. How am I going to recoup? How am I going to recover? I just want to sleep at night and know that my property is safe. That's all I want. I like this.
I get it. It's a hard job. He's had a long day, but the cheese is off the cracker here. This line, and she is frustrating. I don't like the line, but we don't need to reach any of this. This is absolutely a stupid and irrelevant line of questioning. Hell yes. The fact that she lied on her lease application is relevant to this person. Hell yes, she's damaged as a result of it. She hasn't proved it up. It's not in court today. She hasn't put her claim together the right way. You can just dismiss it for that purpose. But no, we're going to go into a I mean, you're bringing this on yourself. You've done lost your mind. And you're making me defend this person I really don't like?
I just want to know.
So, ma'am, can you answer my question? What in that application have you relied upon to your detriment?
I thought she was living with her parents on 99 Arlington. I felt, okay, wanted to get on her own. She's one to meet you. And I thought, oh, what a wonderful young lady. I said, she's going to college, she could be a nurse. She works at Ford. I really thought.
Okay, I'll try the question again, and even if you want to ramble on. What did you read?
Judge, you already can and should rule against her on the law. Why are we launching into irrelevancies? I don't understand it. And you're tired and you're embarrassing yourself.
Rely upon to your detriment in that application and renting to Ms. Lyon.
I relied on the fact she wasn't being evicted of her property. If I had known that, I wouldn't have.
That's a good answer. My God, for the first time today, you made her look smart, Judge.
It's like, you know,
And you did not do a search regarding Ms. Lyman.
I thought this application is risk-free versus reputable company for background check.
Absolutely. With an attorney, she would have won this. The facts are there, but she didn't set it all up, and she should lose. She should lose today. Absolutely, she should lose today as a matter of law. I don't have a problem with that. If she was represented, she would win. But, you know, this is where we are.
And I didn't see any evictions. There was no evictions on the report. So I thought, okay.
So they didn't pick up on it because there was no eviction. She might have been in court, but there was no eviction.
The locks are effing changed, and she admitted it in the last hearing. There's more than that, but you don't have to go any farther than that. It's over right there.
What did she put on there that is fraudulent in your mind?
Her current address.
Are you simple, Cedric? Seriously. She lied about the place she was at because she was being evicted from the other place, if you are to believe her story. I don't know whether and you didn't prove that up. You actually asked that question with a straight face like you're confused? I'm flabbergasted.
Why would that not have been her current residence if she were in the process of eviction?
Because she was living on Landlords, which was the time.
And you relied upon that. Did you do any other searches, anything regarding Miss Lyman prior to renting to her? So you took what she said
I'm sorry. Apparently it's flabbergasted. I forgot.
in the application, put it through to a company, and relied upon that. So in point of fact, you didn't necessarily rely upon what Ms. Lyman said. You relied upon what the company gave you back.
But
And they relied on the information they got in the application.
and what she hand wrote, no, it wasn't just the company, sir. There's also stuff she hand wrote. It's her current address was 99 Garland.
But you took the information that she gave you, gave it to a company, They ran it.
You took your, and we're assuming her facts to be true arguendo for this purpose. You took her fraudulent garbage information and gave it to a company, and they accepted that fraudulent garbage information and then made a bad recommendation based upon it. How are you harmed? Seriously? You're asking this? I know you're tired, but you're asking that in open court on YouTube. Wow.
And that's what you relied upon to rent it.
There was two things. That was part of it. Yes, sir. Yes, sir. Ultimately, you're the judge and you're right. So I'm not arguing.
Well, I'm asking a question, ma'am.
It's not what's fair. Whatever you think is fair, I'm the one with whatever.
Ma'am, I just asked a question.
It was an extremely dumb question, but that's what he did.
You didn't rely upon the application. In fact, you relied upon what this other company had reported back. Right?
Yeah, they said, and they said,
Okay.
they only showed two addresses. It was the 99 Farmington and the PO box. They did not show the Maplehurst on their search.
Let me try again. And
Yeah,
that's
please
what
do.
you relied upon to do the search.
Yes, sir.
I know.
My fibers are fully gasted. Absolutely.
What does that company require that you give them to do their search?
I think they charged us like $39.
They charged me 50.
And what information is submitted to them?
She didn't give notice. None of this matters. Dismiss the claim. You're going off in things that don't need to be done, and you're doing it wrong. So you're just needlessly embarrassing yourself here, Judge Simpson. And I like you. Stop it.
Driver's license, maybe for pay stub. Whatever she puts in the, in. I never had to.
This is a company that you use, and it then comes back and tells you this person is okay to rent.
I mean, they said her credit score is low, and I, she had student debt, and it's not perfect, and I don't expect anyone to be perfect. But I didn't see any evictions. I didn't see huge red flags. Yes, sir. Yes, sir. Yes, sir.
So that's what you relied upon to rent her,
Yes.
not the application that's been flaunted around here. It was the report back.
The report based upon that application. You've got to be. I can't believe he's saying these things. I can't believe it.
From this company.
I don't want to make you angry, so whatever you want.
Ma'am, I am not angry, and don't try that game with me. If I get angry, you are certainly gonna know.
All right. Gotcha.
You typed in information to a company. They came back and gave you a report, such as a credit score, the blah, blah, blah. Can you point to the provision in the lease that
please.
incorporates the application into that lease?
I've got nothing nice to say.
There isn't one, is there?
That's just what I used to, decide on.
If the application is not incorporated into the lease, Then how do you evict her for what you say is a fraudulent application?
At this point, I'm not asking.
Who cares? She doesn't have proper notice. There are a lot of good reasons to evict this woman. She hasn't proved any of them up, and she hasn't satisfied the statutory requirements. So why are we talking about it? Bounce it like you're going to, which is the right call. Stop embarrassing yourself on the side issues that are irrelevant for today.
Asking for my rent. She said, oh, I
You
know.
filed a termination case to evict her.
So fair with this whole thing, so. I just want to get the rent and have somehow see my house. That's all. Somehow make sure my house is okay, so I.
Well, I don't know how you're gonna see the latter of that, because at this point, I'll be honest with you, I think you've been harassing her to the point that you've interfered with her quiet enjoyment of the premises. And she may be entitled to damages for that.
Perhaps. But she hasn't proved that for sure. And she would need to get an attorney to do that right.
I haven't made a final decision on that, but I'm just going to tell you, you can't go around rant to somebody and say, and it's one, you can't then go around and just say they're a crackhead. You might look, you might say, oh, and think to yourself, gee, Miss Lyman looks like a crackhead. I'm just saying, for the purposes of this example, I'm not saying that about you, Miss Lyman, but you might say she's got sex offenders living with her. You might say all of that stuff. It becomes a whole different issue when you begin to disseminate it to other people. And maybe you don't get this, but with regard to the alleged sex offender, I have no idea if he is or not. There's a whole registry regarding that. They're required to give their current address.
I'm just concerned, sir. I'm sorry.
Hey, Judge Simpson, have you ever seen somebody, not follow court orders? Just curious.
There's a lot of children running around.
It doesn't matter whether you're concerned. I could be concerned about whoever out there. I don't just go around saying to people, well, they must be a rapist.
I agree. It's poor form. That wasn't proved, and she never admitted that. He is assuming that now, and it's not a good look. Do I believe her? No. Do I think she slandered her on the side? Yeah, probably, but it's not before the court, and you didn't elicit that, and that's what you're saying. I don't know.
Oh, somebody's going to lose. I'm going to tell you that right now. It keeps up.
Oh, she did admit it? Oh, maybe I missed that. If she admitted that, okay, fine. It's still not before the court. It's poor form, but it's not before the court. Nobody has a defamation claim up.
At this rate. But I'm going to tell you what. Ms. Lyman, was there any other questions you had?
No, that's really it. I did wanted to say that I do have physical photos that I can admit of the property.
Well,
Nah, you don't want those on the day of trial. Just save those. Save those for the Supreme Court appeal, okay?
let's do it this way.
I must have missed that.
And correct me if I'm. But Ms. Anderson, otherwise I'm going to need the text messages. But You told or intimated to the neighbors that there was crack use at that house.
I just said I saw a crack pipe.
That's all you said?
That's all I said.
Do you have, is that what's said on the text message?
I believe, I'm not sure if she CC'd the court in it, but it had like multiple messages with her and other people and stuff like that as well.
Okay, I'm sure she said something like that. Now, is everybody confident that that's not true? I'm not saying it is or it isn't. I'm just saying, are we all 100% confident that this is a made up lie? I'm not. We certainly aren't going to get to the bottom of it today.
Saying that it was a rapist in the home, and then people were like, what is that? It was a
Ma'am, stop. Go
that
ahead.
it was a sex offender in the home, and then she had people like, what is wrong with her? Oh, you need to get her gone, just different stuff like that. She has sent emails with the photos of that, yes.
Well, at this point, I'm not going to need the copies. Anything else?
Nope, that is pretty much it. And just the written thing that about my deposit of the $750, that's it.
Anderson, anything else from you?
I did look up in public records for iChat for her uncle, and it did say that he.
Okay, did it give an address? Did it give an address? So how do you tell the people around there that he's living there?
That's what they said. I don't.
I just want to say the person that she keeps claiming that's my uncle, that's not my uncle. 2 different skin colors is what she's going by. But
Yeah, what, ma'am?
on
Why do you keep interrupting?
the person that she's saying is my uncle is not my uncle. She's going off of the police report, but it listed 2 different appearances, and that's all I had to say. She just searched my name up and just tied that to me.
Oh my God.
She said that in the email as well.
I want to understand that.
She said she searched my name up and it said
Your name.
yes, my first and last name. And she said that Google or whatever she searched up in said that he was my uncle.
Is it your uncle?
No,
So this person she's talking about is not related to you.
that's not my uncle. No.
He's related.
Is he related to you?
Yes,
What is he?
a cousin.
A cousin.
Yes.
Okay.
Has he ever been at the property? No, if that's what I'm about to say.
So, okay. Just so that I'm clear, the person,
This is all terrible and unnecessary. It's absolutely unnecessary. We've long ago figured out she doesn't have. Oh, okay. Well, let's see what he does.
is a cousin of yours,
Yes.
correct?
Yes.
And that cousin of yours, the one that may have this conviction, has never been to the property.
Correct.
So he is related. And he should be on the registry. So while the landlord's insane and like over the top and crazy, she really is. And she does wild stuff. I mean, there's some basis for it, you know? I don't know what I'm not saying, but like, why would you get into this swamp? You don't need to.
So, Ms. Anderson, you found somebody who was related to her Do you have any personal knowledge that that person?
Oh yeah, yeah. Get on your high horse now, Judge Simpson. Talk about what a horrible, what an unhinged person she is. After you verify with her that she does have a relation that fits that description in the area. I'm not saying everything's right. I'm just saying now look what you're trying to defend.
Had been at the property.
Showed the picture of the neighbor from Facebook.
Oh my God.
Because he was saying that the uncle lived there. He said, so he spoke with the mother, and the uncle lived there. And I said, does this kind of look like him? And he said, yeah, it kind of does. And then I started doing my searches. So this is all based on me doing my searches and trying to figure out who was in my house, who was living in my house. I didn't know who was living in my house. I was told that our money was there and it's unwilling to. So what am I supposed to do? I mean, I'm not there. Watch. This is what they told me. Oh,
And this is the same exact problem he got himself into with the pot lady. And I'm not talking about pot as in like the substance. I'm talking pots as in like plant pots. Where he just assumed a whole bunch of nonsense and got ruined for it. And he's doing it again. I'm not saying the landlord's right about everything. I'm not. She's out there and speculative and doing stuff she shouldn't do or whatever. But you know, she doesn't sound so crazy after you question the tenant about it a little bit.
There's not a question. You can have a seat. You may step down. That's all right. Here's what I'm going to say. You filed this complaint for unspecified violation.
What'd you say, sir? I didn't hear that.
You filed this complaint for unspecified violation /fraud / misrepresentation of person in lease. Which I believe those are two different things because you said you were dealing with somebody else and not Miss Lyman.
Yes, in the beginning, I was dealing with Joe, that lady in the back, introduced herself, Joanne. That's who I was dealing with. She's her mother.
And persons in home and non-payment of rent.
Yes.
Those are the 5 bases. I'm going to tell you, and I'll just say this, and I'll let you guys give whatever statement you want to regard. Violations of the lease are tenuous at best. Fraud and misrepresentation of the person in the lease, which is this other person. Ms. Lyman has been here when the court's required her to be here. It's Ms. Lyman.
You can get the transcript. It depends on the scenario.
The fraud.
Very complicated.
Stop. The fraud. There would have to be some type of reliance on something, but that's not what you relied upon to rent. So that's tenuous at best. Other than somebody's speculation, which is actually hearsay based upon hearsay, because supposedly they're the persons that are telling you X, Y, and Z. I have nothing to say that there are other people in this home other than your statement. And it looks to me like the rent's paid. What I do, however, see, and I haven't come to a final decision on any of this, I'm just telling you where I'm at, is that there's been an interference with her quiet and useful enjoyment of the premises and continues to be. And that there are potential damages for defamation, which relate to that quiet and peaceful enjoyment of the premises. So here's what I'm going to do. If you say you want to resolve it, then you need to resolve it. But I don't think, quite frankly, Ms. Anderson, you're in a position to get everything that you want.
Okay, sir. Whatever.
So you just have to talk. I'm going to give you two a chance to go out and see if you can resolve it. If not, I'm going to come back in and I'm going to resolve it. And I'm going to tell you that somebody is going to be very, very unhappy. And I'm not saying anybody has to do anything. Right.
Let me guess that somebody is the landlord and now they have zero leverage to negotiate anything. He pulls this trick a lot.
I think if one looks at it, you can see where your strengths and weaknesses are.
Go do whatever the tenant says.
Now, if you want me to make the ruling, I'll make the ruling. I don't have a problem doing it. I can tell you with reference to the claim of the monthly visitation, not going to happen. $750 is a curious question, but may have to be litigated another day. Because as I recall from the previous proceedings, you had agreed that it would be
Thank you.
refundable. But now today you seem to be saying that it's not, or that you're placing under impossible conditions.
It's refundable.
That would. Lyman, you politely raised your hand. What would you like to tell me?
I was just saying I would want to break off and talk to her. That's all I'm saying.
Well, I'm going to see if you two can talk to each other. And all you have to do is agree upon a number. I don't really care how you got there. If you don't agree, you don't agree. I come back, I'll make the call. I don't have a problem. Okay? Court's going to stand in recess. You got 20 minutes.
All right.
Nothing to say. You know, we're here.
Just before we become emotional, I'll shake this without expression.
Maybe seated. Yes. Go back on the record of the case of Anderson versus Lyman. Did you folks come to any agreement or no?
No.
No. Okay, very good. That's fair enough.
What I said suggested?
No.
Oh,
And I say it that way because the reason is that I did want to know what that process is because I've got to make a decision on it. So I don't want to know that. If there was an opportunity for you guys to address it, then you could have. And Ms. Lyman has indicated you didn't come to an agreement. Anything you want to say in regard to closing arguments, Ms.? Yes.
Oh no.
Yeah, I'm willing to waive,
I don't. Go ahead.
sir?
Go ahead. This is closing argument. Go
Yeah,
ahead.
I told Ms. Lyman that I was willing to waive the late fees. To waive the court cost. Give her the $300 for refund for security deposit. So I would yes for $3,000 for September rent and then $143.93 for May water. I think that's fair. And I also hope I'd be willing to write a
That's kind of not how it works, but it's ultimately, and she's been crazy throughout, but ultimately that is a very reasonable approach at this point. What you want to do is you want to have it resolved with her and say, okay, she can continue for the rest of the lease. And then I want the rent current. And that would mean turnover of the escrow of the amounts in escrow plus the current rent. That's what she's asking for, and waiver of all the other issues. She may or may not want to do that, but that's ultimately, after all of her wackadoodle stuff, she's arrived. It took her a long time to get there, but she's arrived at a reasonable position now.
statement about the security deposit being refundable if it's in room swept condition. So I thought that was fair. So all I would be asking for is $1,143.93 for September rent and May water. And then I
1,000.
3,000.
Agreed. He's going to throw them out. A lot of judges they really don't like those, but to her credit, she did figure out. And it was obvious to us, but it's not when you're involved emotionally, it's not always clear.
$143.93, and that gives her the $300 credit you wanted to give her for the security deposit for September rent. That's waiving all late fees and waiving.
Yeah, probably, because you have a paralegal do it, and you're gonna have it's one appearance, and this thing's gonna be done. You're not gonna have to go to hearing. You're gonna have everything under control. But if you do have to go to hearing, it's an hour. That's it. You call in some witnesses, you call in you lay the foundation for whatever evidence you want. Boom, and it's over. It's over. And if only one of them is represented, the other side's screwed. There's enough. The landlord should get her to catch up on rent and to change the locks back. That is very, very clear. But either one of them facing an attorney will lose 100% of the time. If they both have attorneys, it's resolved and it never goes to hearing.
Cost. And so I'm just asking for rent, and then I would be willing to sign something giving her security deposit back, as long as it's, clean, so I don't have to hire somebody.
Dealing with the security deposit. All right.
That's
Lyman.
I feel that I should be compensated because she gave out my social security number and copies of my ID, which was attached to the email. A picture of my ID and my social was at the bottom. I feel that is defamation to my character, and it has the whole neighborhood.
Please. Oh, please. This is what you brought upon yourself by implanting that idea, which you didn't intentionally. You could have a resolution here, but now we're on this red herring of defamation, which really isn't it. She probably said some stuff she shouldn't say, but it probably didn't rise to the level of defamation. Let's be honest. That's what's going on. It certainly hasn't gotten near that in court, and it's not before the court. But now you've put her full onto it, and this thing's now unresolvable.
In that email, I do not know them people at all, and my social is very, very sensitive information.
I did not give her social.
I feel that
Miss Lyman, hold on. She did not interrupt you. Go ahead, Ms. Lund.
I feel that the late fees are excessive by some compensation of the rent, probably at least half if possible. If not, that's fine. Just think, just some type of.
Really? You're confident this was defamation?
It would be nice just because I haven't been able to enjoy the home since moving in May. This rent, I feel like I owe $2,267 because I paid an extra $200 in June.
Hold on a second. You're arriving at that figure.
Exactly. That's the thing. I don't know if it's true or not, but I mean, there are other considerations that we'd need more information than just sort of what got slopped around here on the side of effectively an eviction proceeding.
Coupled with what you put into escrow.
Huh?
Is that? I'll let you finish. Go ahead.
I feel like I owe $2,267 for the month of September because back in June I paid an extra $200 and I moved in after May 1st. So $533.
Okay, this right here, once we clear past this defamation BS, now she's getting real. You can find common ground between the two positions of the landlord and the tenant at this point, but we've got red herrings injected into it.
Dollars should have been prorated. I got that by dividing 3,300, then divided by the 31 days that's in the month of May, which came up to 106 and some decimal points. Then I times it by 5 and got $533.
106 and some decimal points. Whatever. What she's saying, I would want to recheck it with the calculator, but what she's saying is rational here. Rational and comports with general notions of law. Both her and the landlord, they're not exactly the same, but it's very, very close now.
So that's how I feel that. Then from the security deposit of the 300, I added all that together and got $1,033. So I did 3,300 take away $1,033 to get $2,267 for the month of September.
Yeah, well, we lost confidence when you said and some decimals.
And that's pretty much it. I just want to be able to enjoy the home without being bothered or anybody popping up or watching me.
All right. Thank you, Ms. Lund. Ms. Anderson.
Yes, sir. I wanted to clarify our tenancy, our lease goes with this too. So what I explained to her, the reason why I didn't wait the first month, started on the 5th and we go to the 5th. To the 5th. She thinks that I should prorate it. I just started.
Oh my God, I could mediate this in 5 minutes. I would need some cooperation. I would. But I can mediate this in 5 minutes. We are nickels apart at this point.
That's why I didn't prorate it. Not due, till the 4th, not the 3rd month. I was trying to explain that's why I didn't prorate the first.
Well, thank you both very much. What I'm going to do is I'm going to go through these calculations, try to figure this out. There will be no additional argument or witnesses on the case. I will render a decision and I'll set it for October 14th. Go ahead.
Oh, I was just trying to I turn these photos into you?
No, I don't need it. I'm good.
Okay.
So, October 14th, 2025, 9/8. Yes, Ms. Andrews.
Can I get the 2 zip drives that I didn't include as evidence since they have family photos on?
Ma'am, once I am done with the case, we have indicated to you, I will make a decision on that. I've told you that time and time and time again. But they were submitted to the court, and I had not yet heard the trial nor rendered the decision on the trial. I will then make a decision.
That's only
Judge, I've got spreadsheets and videos of everything at home. Should I have brought them today?
photos of my little boy.
Ma'am, what did I just say? Thank you.
Thank you.
Well, there you have it. I'm going to the end. There we go. Okay. There you go. All right. I might have been a little hard on Judge Simpson tonight. He deserved every second of it. I still like him. I still think he's a smart guy, but he's got blind spots, and he gets himself in he digs himself holes in these things every time. Every time. The landlord doesn't have her stuff together. Period. End of statement. She doesn't. Having said that, the tenant doesn't either. The judge sees that, and I think it's poor form to be sitting there like making accusations and all that stuff about your tenant. I'm not in favor of that or whatever. But we haven't proved up a defamation via this hearing. Not even close. Not even effing close. And the claim is not before him. So the question we have here, I think he dismissed I think he dismissed. He's going to do something probably better for the landlord than I would. By the way, I don't like the landlord, and I don't like the tenant either. Like I've said it 100 times. If they can both lose, I'm perfectly happy with that. But I would dismiss this thing and just say, look, you didn't have the right notice to get this thing done. You didn't file the things right. It's dismissed without prejudice. Go find an attorney, come back and do it right. Yes. I would have, probably on a review of the pleadings. That's what's really hard with these things. They're super intricate. Like I said, it's not rocket science stuff, but it's all these intricacies that people don't know. So like, it's really stupid and arcane. So like you'll have like a 5-day notice, but that corresponds to a certain type of eviction, or a 10-day notice. So like you can have it, if it's just for non-payment of rent, then you can't accept rent, or your that screws up your case. But if it's for some other reason, then I don't know. And literally you go from one county to the next and it changes. Forget about Illinois to Michigan. I mean, Cook County to DuPage County is a whole different world. You guys don't know DuPage County. It's a lovely place. I hate court in DuPage County. Out there on County Farm Road. It's no good for nobody. Anyway. All right. Well, let's say Lake County then. We'll or Clay County. I don't know. That's Clay Township. I don't know what county that is over in Michigan. Anyway, I think the judge got himself embroiled in a bunch of side issues he didn't need to, and then showed a glaring bias that he also didn't need to. While I say all that, I think some of the actions of the landlord were absolutely reprehensible. And also of the tenant in this case. But what do I know? I'm just a simple country attorney trying to bang out a living in the Midwest.